Thank you. Okay, welcome back. The House Judiciary, we're going to be looking at H 657, an act relating to enabling unaccompanied homeless youth to obtain certain services without parental consent. And we're going to be having two witnesses, Kim McManus from the Department of State's Attorneys, and after Kim, Adam DeCrasson, a lobbyist for Vermont Association for the Justice. And the first witness will be Kim McManus.
Thank you. For the record, Kim McManus, Department of State's Attorneys and Sheriffs. Here on H657, following the testimony yesterday, I believe the specific question for our department was going to be around Section 4A on page 10, which is the addition to 13 VSA 1311. I will warn you, we have another issue to bring up. So I will try to keep it brief. But we, as a general matter, have no issue with adding that a person providing assistance pursuant to 33 VSA 4908 is added as an exception to the unlawful sheltering. Philosophically, no problem with that. We appreciate that there's a vetting system to qualify as an unaccompanied youth, and we have no issue there. The issue we do have, and this is to make sure that the report that is wanted can actually be done and be done by the right individual. So the report on page 21 which asks that our department collect the data around the number of secured transports with specific information about the age, gender, race, types of transports, type of restraints being used.
Can I pause you for one second, Kim? I think we still don't have a printed out version of this, John, right? So just if folks are looking for, it's draft 8.1.
8.1 was the version that I believe was presented yesterday.
Yes.
And that's what we've been working on.
Okay, great. We just don't have it in front of us yet.
Yeah.
Oh, apologize.
What is the
and I can slow down.
657.
I will slow down. All right.
Thank you.
Sure, I was myself, and I sensed I might not be the only one.
All right.
It was emailed to us yesterday by Martin at 11:26 a.m.
That is.
It's about to be posted too.
I'm looking at section 9, page 21. The report requirement.
Okay, and I'm gonna print. Is there anyone who would like a printed copy?
Please.
I got it.
Oh, you're on
Print that one out because it's like 30 pages long.
Okay.
Just tell me.
Gotcha. Okay. I take it back. He's on it. Okay, page 21, section 10.
Well, page 21, it's section 9 of the bill, but page 21, I believe it's L. This section it says starts with annually on or before. Yes. All right.
Okay.
So there's a request for a report, which we absolutely understand. The issue here is that the Department of State's Attorneys and Sheriffs, the data we would have would be for court-ordered transports, not the non-court-ordered transports, which are the transports that some sheriff's departments do for DCF or AHS under contract. And so we're absolutely happy to partner in gathering this information. Even though it would seem like we're the right place for this report, we are not. We tracked last year that we had 12 court-ordered juvenile transports. And so on that information, we would be able to gather the whether restraints were used, et cetera. But for the non-court-ordered, we would need, that would either need to come from DCF, ideally, or from the agency that requested the transport, or from the individual sheriff's departments. So we wanted to flag that. The other piece we wanted to flag in just getting good data, whoever is responsible for the report in the end. The use of the word minor is used here, whereas elsewhere child is used. And we're assuming that the word child is being used because of the definition in this section. And if that's, we just wanted to flag that you might want to mirror the use of child, not minor. For gender and race, more specific on whether that is as perceived by the person doing the transport or as reported. That race data is not something that just by transport we would be noting that data. That would either be collected if this was a court order transport, that would be collected from the law enforcement side. If this was a delinquency, I don't know if the court would actually record that data. That would be a question. And then again, DCF would have that data if this is a non-court ordered transport. So we wanted to just we would encourage folks to spend a little more time working through some of that language and really getting what they want to get. The other part,
Can I ask,
on line 11, yes.
do you mean by that working through the language and getting what they want to get? Is that meaning understanding what's available?
Understanding what's available and maybe tailoring the language so that we or whoever is capturing exactly what you want. And I'll give an example. On line 11, it says, when applicable, the type of mechanical restraint. Probably the better language would be if a restraint is used, the type of restraint, because when applicable, there's going to be some, I don't know, there's some room there that feels a little funny to us. Essentially, if we're collecting some of this data, and remember, most of our data is for internal purposes, we're not really built and designed to be necessarily the data repository for this. But as simple as we could have it, as far as were restraints used, yes or no? If restraints used, what type of restraint? Like just making sure the report language is sort of reflecting that easy collection of information. Executive Director Dumont has a one-page memo that I will submit to you all that just outlines specifically the difficulty right now of us being the sole entity collecting this information and reporting on it. So we will submit that to you because I know you're tight on time. Great.
Any questions for Joe? No? Great, thank you.
Chair.
I know you have witnesses scheduled. I don't know what your timing is like, but I think that a couple of the things that were just specified to can be sort of immediately resolved if I.
Let's get through Adam McCrashen first,
Yep, okay,
not knowing how long he's gonna take.
right.
So since
Mr. Chair, I'll be brief, and that may help you with cleanup across the board. Adam McCrasson, the McCrasson Group, Vermont Association for Justice, we're familiar to this committee when the periodic surfacing of the sentence that says an actor is immune from negligence liability, which is in this bill. Starting at a broad point of departure, very much understand the intent of the bill, the agency for the youth, here to be supportive of that. It's not our part of it. We're here out of standard operating procedure to brief you on looking at this from another perspective. And because so you have a policy choice in this space. And my understanding of having done my homework, but not consulting expert attorneys in this area, right? Because this is such a narrow space, kind of on my own. I understand from the committee sponsor, this sentence is here because it was in the Florida law. And I couldn't find deep origin story for it in the policy committee. Nevertheless, it's here, and let's unpack it a little bit together. This is a statement of what it does, not any rhetorical flourish or spin. When we immunize negligence, you're telling an actor they can be unreasonably careless, cause injury, and their insurance company will not be accountable. Okay. And so the policy question for the General Assembly is, do we intend that? Do we intend to say, because this bill is really about giving the unaccompanied, by the way, when I first saw the title, I was like, oh boy, is this American Airlines like losing a vulnerable young adult? No. Is this medical malpractice immunity for a doctor? Doesn't seem so because of the parsing of the sentence, but I just want you to know why we are constantly bringing a different look at this stuff, because there's always what a bill is intended to do, and then how insurance defense lawyers that take it up a year or two later under unsuspected circumstances can kind of immunize their client. And so the sentence is an entity provider. So we're not talking about the youth here or anything to do with their actions. We're now talking about what a car dealer or a medical provider, what type of care they're bringing to the services or the transaction they're having with the certified youth. And it's those actors.
Can I, Adam, just to
Yeah.
orient folks, can I just say it's bottom of page 9, top of page 10, lines
Yeah.
20 and 21 on page 9 is where it starts.
Right. And a little more stage setting. And again, not here to augur in one way, hard or another, just to highlight the policy question. The certificate. So I'm an unscrupulous car dealer. I have a piece of paper that is being given to me saying this 16-year-old can give me their $2,500 cash to walk away with this car, right? And I don't have to do any due diligence to make sure that this form was validly executed. Okay, so like that is the most plain language scenario I can create for you. We just had course debt come through these committees, and we know the breach in the margin is usually irresponsible or unscrupulous actors. In this case, this is the provision, the liability provision that puts weight onto the business or licensed professional engaging in services or a sale based on this piece of paper. Okay. And I understand it's meant to be there's not a big registry. There's not a lot of, there's not a lot of rigor around the document. But so this becomes the policy question of, do we want the person selling the car or the medical provider to conduct due diligence around their decision to contract or not? Because the immunity provision shall be immune from liability for the determination to contract with the minor. And it's the language determination to contract that makes me believe this couldn't be used to immunize medical malpractice. So that those key three words really tighten this down to like, what am I relying on this document or not? But help me out, counselor.
Well, no, I was just gonna, two questions I had. One is, so yeah, the way I read this is that the immunity is only for liability around the determination as to whether to contract with you. That's the immunization. Like we're talking about housing on this. So the landlord is immune from from a liability around the contract. The landlord's not immune from any other liability around how they're providing the housing, the state of the housing, anything like that.
Premises liabilities.
All of that is,
Yeah.
is about this. So that's why, so I guess like, do you understand that you read it the same way?
I'm building legislative intent that this is about the determination of
Yeah.
contract and the due
And
diligence
that's my.
or the lack of due diligence that's being, the General Assembly is saying you do not have to conduct due diligence.
And then my only other question would be, if, someone negligently, did not look into whether I don't know what the term is, the certificate that the youth holds, and they didn't look into it and the certificate was falsified or was not correct, they would not be protected by the liability,
No,
immunity, correct?
they would, because they're saying you don't have to be careful
But
in the determination of contract.
But wouldn't that only apply if the youth is actually certified?
Well, herein lies the question, I would suppose, and I don't know, because I'm worried about the bad partner
Yeah,
and the vulnerable. These are by definition vulnerable
yeah, yeah.
adults, right? And so like,
Or vulnerable
I'm here bringing heightened scrutiny because these are
Yeah.
vulnerable young people and
Yeah.
So I'm just highlighting, what are you expecting the people who are doing business or providing medical care?
Yeah.
And I'm glad it's a low key hearing setting because I'm not trying to kind of signal a bunch of
Yeah.
fights over youth medical rights at all. I just know, of course, that is like a space where
Yeah.
people are vulnerable.
Okay.
But how do we know if the form is valid or not? You should make a phone call to whoever signed it and say, did you sign this form?
Mhm. And you see this as,
Or did somebody print it and say, I want you to go and take $25 out of your
yeah,
mother's drawer and let's get out of here. Like, so
yeah, and you would read this as that it would release them from liability for that type of
the
due
due,
diligence.
the due diligence to determine the contract is the narrow question.
Yeah,
And then I'm saying, I think this entire piece is superfluous. Often we're in this piece of the conversation because someone went to a committee and intended that they want this. So brought forth in Florida, deferred to the policy committee where there's, providers saying without this, we can't
Yeah.
sign a lease. But I've said enough, honestly.
Thank you for raising this. What language would you suggest to clarify that it is very clear?
That it's well, which part? Because there are two parts. We would strike this entire sentence because it's a matter of course.
So if
and
we're going to
look at
keep
the
it, what
carrots.
language would you recommend so that we are very clear that it is only about the contract?
Well, thank you for asking. My colleague Jessica Oski gave me in the alternative suggestion, which is to add the word certified in the definition, contracts with a certified unaccompanied youth. So that it's
What is the definition of certified?
as
Add in the bill.
it's in the bill, yeah. And it's that this group of people from your support structure are signing this form for you. And so that's the certification process.
So you would prefer if we just struck it? I think that's going to happen. So if we don't do that, this is your recommended language.
To make it very clear that it's yes, and then I'm here to build the record on it's the determination, because we very much do not want these folks to be victims of medical malpractice and then lose their rights.
And I
Yeah.
don't think that's our goal
Yeah.
either. We
Yeah.
want to find a way forward on that. So
and just to clarify, that language is to add certified on line 21 at page 9. That's it for the professional who contracts with.
The dot down in the bold.
Yeah, okay.
I think that's, you see according to the section, I mean, there's a little bit of a loop here, but saying certified at least makes it very clear
Yeah.
that that's the cohort of youth, young adults.
Yep.
People that we're talking about.
And just to put a finer point on that, and if a youth has entered into a contract with with a car sale.
Unscrupulous car salesperson.
Or not unscrupulous, but someone who with a falsified certification, then the immunity would not attach, would not
No, I think it would.
when we add certified.
Yeah, even that. Yeah, like if you're relying on somebody giving a piece of paper that looks like whether they printed it and faked it or it's the real one and it was signed. The doctor or the car salesperson is saying, I got printed a piece of paper that looked like this. There was no expectation. I checked to make sure that it was legit.
Maybe we should add that piece then.
I think that's what I'm trying to say, that like, even if we say professional who contracts with a certified unaccompanied youth, we're still relying on the professional to have some idea of what these certificates look like or what a valid certificate looks like.
Using a negligence immunity clause to back into this piece of the conversation is awkward for you to know. You know what I mean? But I'm highlighting for you the intersection where it matters,
Yeah.
which is double checking that it's a valid form.
Yeah.
And again, I'm tiptoeing around this topic. I'm not policy expert, and I understand these are super vulnerable people with agency. And
Well, I think it's better not to tiptoe when we all understand that we're all trying to help the youth. And understanding that that's actually what you're doing too. Like everyone's here trying to help the state.
well, thank you for seeing it that way and saying that, because yes, we do not want them to be treated carelessly and
Right,
harmed, which is
right.
the
And then
essence of the
rights
negligence
to-
statute.
Yes. Okay, so then I'm just trying, like, would your recommendation be, and of course, I'm not saying this would happen, but that we should go even further and say that there's a requirement to check on the certificate, or?
I don't know. No, I'm in over my head at that point.
I'm just trying to think through, like,
I guess also the liability that we are shielding here is like really narrow because it's just so I guess like the liability is like they were not supposed to contract with a youth.
right.
So, but it's not any of the conduct or anything like that.
It's not, I was not supposed to contract with this youth, and I did, and now the car that I knew to be defective is, showing all of its defects, and because of this immunity clause, the youth who bought the car.
I think that they could still
Wait.
go after the car salesman for the defective.
If a certified youth, it's still go after,
Any youth, this doesn't.
Yes.
I guess maybe it would be like, I guess, I don't know.
Well, the scenario is you took,
factual-
you, I mean, to stick with a
Yeah.
plausible scenario, somebody takes $2,500 from their family because they're under pressure in a unhealthy pairing.
Yeah.
This is the course debt scenario. Fakes this form, buys the car, and the family is like, where'd our money go? And where's our
Yeah.
16-year-old daughter? And the car dealer's like, well, I saw him driving out of here after I took your money, and no, I didn't have to check because I don't have to do, there's nothing that makes me have to be careful here. The General Assembly said, no carefulness required. Again, immunity provisions are an awkward way to back into this.
yeah. But, and
So-
and I don't want us to just not understand it and then throw something in.
So without going any further, if we stick either eliminating or adding your language, do you think that would satisfy?
If this provision isn't
Want
there,
to go?
we're always going to surface and say immunizing negligence provision should be removed because you're saying it's okay to be careless and hurt people.
And that's your first choice,
Yeah.
but you, if we don't go in that direction, then you had that language to replace.
Just makes it super clear
Right.
what we're talking about so that we're not in the circumstance where American Airlines are like, you're outside of this narrow prescriptive thing. It's a belts and suspenders piece. It doesn't change this fundamental question. And we're in low probability scenarios here that I'm articulating. Very, very low.
For the sake of time, one more question.
Yeah, it's a.
And then I want to get Ann in for at least a minute because I know and it wouldn't be much more than that, but.
Yeah. Would it work to, if instead of immunity, we're using language that says that these, any entity provider, may reasonably rely on a, certificate? Or,
That would be a policy statement in the affirmative that
Yeah.
would avoid this labyrinth of gray area that's being created and probably serve the policy purpose. Again, this is inherited from Florida where they put this in each bill probably 3 or 4 times. It's a completely different civil landscape there. In Florida, gross negligence is probably what negligence is here in the litigation environment. Right.
Great, thank you, Adam. And Ann, you had some comments that you wanted to make?
Representative Van Donahue, thank you. And I'll 1 minute here for then maybe some more time later. I think we had absolutely no intent of having the sheriffs who do the judicial transports to have any involvement at all with any data reporting for the DCF subcontract. There is another part of the bill that puts all those requirements forth. We were basically unaware that there were other sheriffs somewhere doing other transports until we had testimony, I think, on the last or second to last day. And we were like, oh, and we heard, 12 a year. We really should have the whole picture. We would like to have the data on those kids also, which DCF wouldn't really be, and so forth. And 12 a year, you got a problem with hand counting them? No, we got no problem. This was through, and because I wasn't ready for this question, I don't have his name on the top of my head, but we had testimony from, is there a Tim? Yes, Tim, thank you. And he's the one who explained all this to us and said, yeah, I mean, that'd be no problem. And the chair then said, well, don't be surprised if you see that ending up in the bill, because it wasn't in the bill. We didn't know about it. But in terms of some of the details that were being mentioned, I think we could probably easily work with them to get it, because we just mirrored the language of what DCF gives us on the much bigger group. And there might be some fine tuning we need to do on that. Minor was very deliberate because we wanted to capture 16 and 17-year-olds who are being treated as adults.
Be continued, okay?
Yes, thank you. That I got going.
Because people have to leave.
Yes.
In short.
You got the idea that there's.
Yes, absolutely.
Yeah.
Nate, we can go offline.
And I can speak to the immunity question.